NACDL is the association of the nation's criminal defense bar.
What is reasonable doubt? Or what is proof beyond a reasonable doubt? I mean, that's a question, I think. And I think it's a reasonable question given that it's what the courts are asking jurors to use to put our clients on buses and send off to prison. And it's a question that I think is a fair question. And in preparation for this talk, I must have talked to 15 to 20 different people, and I asked them that question. What is reasonable doubt? And not one of those people told me, I don't know what reasonable doubt is. Not one of them told me what they didn't know what reasonable doubt is. All 15 or 20 of them all knew what reasonable doubt was and told me what reasonable doubt was. Somewhat with a question or somewhat unsure, but they all were quick to give me a definition or what their understanding of reasonable doubt was. The one thing that they all had in common was that they all were frameworks for making decisions. They all were decision-making frameworks. But the one thing that blew my mind was that every definition, every explanation was different. Every person I talked to had different definitions or different understanding of what proof beyond a reasonable doubt or reasonable doubt meant. And I shouldn't have been surprised but I was surprised, and I shouldn't have been surprised because everyone has a different way of making decisions. I mean, when I think about it, right? My plumber, whenever I call him out, he comes out and he's checking everywhere, looking for leaks. And he looks continuously until he can find a leak. And once he finds a leak, he shuts everything down. So his way of making decisions about figuring out which way to find out whether or not there's a leak is different than mine. And when I think about teachers as well, teachers come in contact with a lot of children. And they make decisions all day, every day. Many decisions. I mean, they're probably making 10 to 15 decisions an hour, right? Involving children. And oftentimes they're quick decisions because they can't spend too much time thinking about it because something else might pop off or break off in their classrooms. So teachers have a different way of making decisions. And definitely real estate agents do, because they got to make sure all the paperwork is signed. Every signature is signed. And they're motivated to make sure that the decision is tight. They're looking at things differently than I do. So I shouldn't have been that surprised. And we all know engineers. Everything has to be really exact with engineers. When they're making decisions, their decisions are fairly exact and precise. And they're looking for precision oftentimes in making decisions. And this beautiful lady, this doctor here, I actually asked her this question. The other pictures are stock photos, but I actually asked her what reasonable doubt was. And being a doctor, caring for patients, and loving patients, and then on top of it, being an African-American physician, she was very meticulous in her definition and understanding of reasonable doubt. But the thing that kind of still surprised me that they all were different. But I knew that everyone had a decision-making framework. Everyone I came in contact with had some way that they made decisions, some way that they placed values to the decisions that they made. And usually when we have something like reasonable doubt or some huge legal concept, we're looking for some guidance, right? We're usually looking for some guidance, and we don't want to have some definitions of reasonable doubt that people have. Because not all definitions are good. Not all definitions are favorable to our clients. But usually we're looking for guidance and we're seeking it from these people, from the Supreme Court, right? Something so important, right? Constitutional, like reasonable doubt, we think that the Supreme Court would have weighed in on it. But unfortunately, the Supreme Court hasn't given any direction as to reasonable doubt. They haven't given direction as to whether or not there's a definition of reasonable doubt or whether or not you should or should not. In fact, the words reasonable doubt appear nowhere in the Constitution. It's created by the Supreme Court. And this Supreme Court, the Supreme Courts that we've had recently, haven't really given any instruction or direction to us for jurors. All they pretty much have said is that it's not required to be defined. So in your state, you don't have to have a definition of reasonable doubt. Jurors can figure it out for themselves. It does not have to be defined. But if you do decide to define it, it's okay. It's constitutional for you to give a definition, and it's constitutional for you not to give a definition. So we've gotten no instruction or direction from the high court. So what's been happening as a result? Primarily, courts have been given definitions. Courts and judges themselves. Some states actually have a codified instruction on reasonable doubt that you'll get. Some states don't have them. And the states that don't have them, generally judges still attempt to define what reasonable doubt is. In those states that have a definition, judges explain that definition of reasonable doubt. And in addition to judges and courts making definitions, we also have prosecutors who are defining reasonable doubt. Prosecutors also defining reasonable doubt. So where does that leave us? If we got the standard that they're using to try to send our clients to the penitentiary, the most important thing for our clients is whether or not there's proof beyond a reasonable doubt. If we're in that type of situation, where does it leave us? It leaves us with having to fight about reasonable doubt. We've got to fight about reasonable doubt. We can't accept the court's definition of reasonable doubt, and we certainly can't accept the prosecutor's definition of reasonable doubt. We've got to fight and define reasonable doubt. So in this talk, I want to talk to you about first objecting to definitions of reasonable doubt. Because most people don't object to the definition of reasonable doubt that the prosecutor or the court gives. And I want to talk to you about objecting and tell you reasons why you should object to definitions of reasonable doubt. And then I want to give you some examples and illustrations about how to define reasonable doubt for jurors. All right, so I want to talk to you a little bit about objections, the objections you can raise. Generally, courts have upheld objections to reasonable doubt definitions that aren't clear and unequivocal, that mislead the jury, and that shift the burden, and of course, that violate due process, those that violate due process. Whenever you have an opportunity to object, I encourage you to constitutionalize your objections because, one, it gives you a greater chance you'll win. If your objection is based on the Constitution or some constitutional principle, then the chances of you winning are greater. And second, it gives you a better chance for appellate review. Courts in most states will use a different standard in reviewing constitutional error as opposed to just plain error or any other types of error. And then third, it deters the conduct of a judge. Whenever I start talking about the Constitution and objections, most judges usually pay close attention and most are usually hesitant in their actions. And with reasonable doubt, the definition there is an objection to it that it violates due process is probably your best constitutional objection. Your best constitutional objection. And in 1990, the Supreme Court of the United States, for the first time, actually reversed the conviction and found that a court's definition of reasonable doubt violated due process. And it was in Louisiana. Case versus Louisiana was where the court held for the very first time that the definition, a definition of reasonable doubt violated the due process clause. And in Case, the court focused on three things in the language of the instruction. There was some language that said that the doubt had to had to give rise to a grave uncertainty, and that it had to be an actual or substantial doubt. Anybody see any language like this before? In any of the state instructions? So I see a couple of hands that have actually seen that kind of language. In 1990, the Supreme Court looked at that and thought it was unconstitutional, that it was a violation of due process. Anybody see any lawyers objecting to it? Where they're from? Good. We got one person, but not only one. And the court also says that what is required is a moral certainty. So the Supreme Court thought it was unconstitutional because it made the burden a lot lighter. It meant that it had to be a higher degree of doubt than what was required for acquittal under the reasonable doubt standard. So it was like a shifting of the burdens. Now, it isn't just limited to Louisiana. And this isn't something that just happened in 1990. In 2017, right here in Pennsylvania, right here in Philadelphia, there was a judge. I think you guys probably, some of you may know, anybody familiar or remember Judge Renee Caldwell Hughes here in Philadelphia? She gave this analogy. 10 years ago, she was on the bench in Philadelphia. Just now, a lawyer has filed a writ of habeas corpus. In 2017, he filed a writ of habeas corpus, and the conviction was overturned because the court thought that this analogy she used was unconstitutional. And an analogy was simple. She told the jury, she says, imagine if one of your precious ones, physicians, that you were told by the physician that they had a life-threatening condition and that the only known protocol or the best protocol for the condition was an experimental surgery. And you were very likely going to ask for a second opinion. I know if you've heard this. Anyone would ask questions and do research, she explained. But at some point, you've got to decide. And this is the kicker. She says, if you go forward, it's not because you've moved beyond all doubt. There are no guarantees. If you go forward, it's because you have moved beyond all reasonable doubt. Anybody see the problem with that instruction? Anybody see the problem with the instruction? Not too many hands. All right. It assumes you got to have the surgery, right? Because you've got a loved one that's about to die, and they're going to die if you don't take any action. It assumes you've got to have the surgery. So if you're looking at a situation where you got a loved one that's going to die, is about to die, you're going to do everything you can to potentially have that surgery. It is presumed that you've got to have the surgery, right? Whereas with our clients, they're not presumed guilty. If you use this analogy in a criminal case, it's presumed that you've got to convict this person unless they come in and show you some issue, some problem that stops you from going forward, which shifts the burden. Very subtle, right? But the lawyers in his trial didn't object. In fact, the judge had been using this example, this illustration for 10 years, and nobody had ever objected in Philadelphia. Right? On the writ of habeas corpus, a lawyer came back and reviewed the transcript and decided to object. And then the court, in federal court, in the federal writ of habeas corpus, the judge agreed and overturned the conviction. And Larry Krasner, who is the DA here in Philadelphia, decided not to appeal because he was afraid of creating a precedent that may interrupt a whole bunch of other convictions that came through this particular judge's court. So as a result now, he's on a case-by-case basis resolving those cases. And this is new. This is 2019 that he's doing this because the objection was sustained in 2017, and those cases are now funneling through the pipe. And so, what we've got to do in preparing to object is to scout the court and the prosecutor. So we'll know what instructions judges are giving. If we've sat down and we've watched the trial and we've seen the judge give a reasonable doubt instruction, we can pull back and think about it. And does this violate due process? Is he shifting the burden with this instruction? Does it make the state's burden less with the instruction? And when prosecutors stand up, where I practice in Houston, there's a prosecutor who's known for telling the jury that they don't have to be certain for reasonable doubt. The reasonable doubt isn't 100%, so you no longer have to be 100% certain. You don't have to be sure, is what he tells them, which violates due process. Lawyers don't object generally, right? But if you go out and you look at the prosecutor, watch the court, you can scout them and see if there's some issues with their definitions of reasonable doubt. And when to object, I think you object whenever any objectionable definition is given. A lot of people feel uncomfortable objecting to the judge. During a trial, during voir dire, during any phase of trial, they feel uncomfortable objecting to the judge. So my suggestion is if you feel uncomfortable, then figure it out ahead of time. Talk to the judge ahead of time. For example, when you file your motions in limine, if you're on the record discussing the motion in limine, ask the judge, say, well, Your Honor, how does the court want to handle it if we have any objections to the instructions or statements from the court? Ask the judge, put them on notice that you plan to object to statements from the judge or statements from the court, and discuss it during the time of your motion in limine so there won't be any surprise. I typically just will stand up and object if there's something that the judge does is objectionable, but not all lawyers feel comfortable doing it, and they don't do it. So it's important that you object, because most states, and I would say that Texas as well as Pennsylvania, require an objection to preserve it for a record on appeal, on direct appeal. And so you've got to object. And then, of course, the times you're going to see it and when you want to object are in voir dire, because those when the definitions are going to occur. There'll be definitions from prosecutors and the judge in voir dire, and you'll also see them in the jury charge prior to closing argument. So those are places that you want to object, and generally constitutionalize your objections by arguing that it violates the client's due process. And if you do a little scouting of the court before you go down, you can kind of figure out what the definition that they're going to give is and be prepared to object. A second thing to do, and I actually in the papers I submitted, I actually gave you a copy of a proposed jury charge, at least a proposed definition. If you're in the jurisdiction, or if you're trying a case in federal court or in a different jurisdiction, consider submitting a proposed jury charge defining reasonable doubt. In other words, object to the one the court's going to give and ask for your own and submit yours. That way you'd have a clean record. Sometimes some judges might even give the instruction that you're asking for. In federal court, judges routinely change the instruction based on the different objections that have been filed, is what I have found. So I would submit to you to at least submit a proposed definition of reasonable doubt. So arguing and defining reasonable doubt for the jury. Now remember, everybody has a framework for making decisions. I mean, lawyers, doctors, plumbers, teachers, they all have a framework for making decisions. Not everybody agrees on what reasonable doubt is. In fact, most people aren't really sure when they show up for jury duty what reasonable doubt is, but everybody has a framework. And this is where I think story takes place. Or this is where I think story has a place in reasonable doubt and defining and explaining reasonable doubt. You know, when to argue reasonable doubt, I think you argue reasonable doubt or begin defining reasonable doubt in voir dire. Early on in the case, I know most of you probably have used voir dire charts where you have a chart with reasonable doubt with all the standards laid out. How many people have used those charts? Okay, all right. There's a place for those charts, and we'll talk about that a little bit as well. But I think voir dire is a place where you start defining reasonable doubt. And then, of course, an opening argument and closing argument, if you get an opportunity. It's trickier in opening because you may draw some objections, but there are times when you can use a definition of reasonable doubt in opening statement. And certainly in closing argument, you do it. Now, how to do it? I think using analogies and stories is a great way to illustrate reasonable doubt. It's a great way to define and argue reasonable doubt. And I want to give you a couple of examples of that. And I want to also tell you how I develop examples of arguing reasonable doubt. You see them quickly getting off that ride after hearing that? And I think that's so profound, right? Because when you see that, there's so many possibilities when you see a video like that or hear that story about arguing reasonable doubt. You've got a mother who is putting herself on a ride and she's putting her child on a ride, right? Moms and parents and people make those kind of decisions all the time, right? The safety of your children, you make decisions about the safety of your children every day if you have kids. And you make decisions about your own safety every day. And they hear some information that causes them to get off the ride. And so I use this analogy in this story. My Auntie Angel is my favorite aunt. And for years, she was a stay-at-home mom. And she stayed at home with my cousins. And when they got old enough to go to school, she would walk them out to the bus stop. She'd go by herself, you know, usually in some house slippers, and she'd put them on a bus every day and see them off on the bus. One morning, she went out to the bus stop, and it was a different bus driver that pulled up. And she said, "Good morning." And he mumbled some words back to her. And so she paused for a second, holding my cousin's hand. And then she asked him and says, "It was a good day this morning." And he mumbled some more words. And then she looked around the bus and didn't see all the normal kids on the bus. And she looked a little closer at the bus driver, and his eyes looked a little glassy. Not red or anything, but a little glassy. And so she decided to take her kids to school that morning. So she went back in her house and put on her shoes. And then she got in her car and drove her kids to school. And then she went home after dropping them off, and she was doing some chores, and she had the 12 o'clock news on, and she was doing some chores, and she saw on the television that there was a bus with some kids that had turned over. And she looked closely and saw that it was a school bus that she would put her kids on. Thank God nobody was hurt, but she was grateful that she didn't put her kids on because things just didn't look right. Ladies and gentlemen of the jury, Officer Brown is driving that bus. We all know, ladies and gentlemen, that Officer Brown came in and he gave several inconsistent statements during the course of his testimony, ladies and gentlemen. He gave multiple statements that just didn't make any sense. He gave statements that were contrary to what the evidence looked like, ladies and gentlemen. He gave statements that made you question whether or not you want to put my client on that bus. Don't put him on that bus, ladies and gentlemen. Don't put my client on that bus. They want you to put him on that bus off the prison. Don't put him on that bus. And so that might be what an argument might look. And I'll use that argument because it draws on decisions that people tend to make, right? And that story of the lady not getting on a ride is an illustration that we can use to help us develop stories to tell for reasonable doubt. Now, listing reasonable doubts and demanding a response. This is something that I saw done, and I've done it a couple of times, and I think it works exceptionally well. I started my career as a prosecutor. I think he didn't mention that, and thank you, Mike, for not mentioning that. I'm saying it now, and I am reformed. I haven't been a prosecutor for 21 years. I've been doing defense work for 21 years. I was prosecutor for 3 years. But when I was a prosecutor, I tried a case against a lady named Steffi Jaffe Owens, and I will never forget it because she mopped the courtroom with me. up and down. And I learned so much from that trial. My wife came and watched that trial. And afterwards, she told me, she says, I don't know, Eric, I don't know. I think this is not guilty. I think it's not guilty. And in her argument, she made an argument for reasonable doubt that I will never forget. And I've used it a couple of times, but she taught me this, and I want to honor her with it. She made the argument that I had to respond to all reasonable doubt because my obligation was to prove the case beyond a reasonable doubt. If there was one reasonable doubt, then the jury was obligated to acquit my client. And then she proceeded to list every reasonable doubt individually. She listed 18 points of reasonable doubt individually, wrote them all on the board, and went each one and argued what the reasonable doubt was. And then went to each one and put points there. And then afterwards, she challenged me and said it was my duty to respond to every one of those points of reasonable doubt. And if I missed just one, the jury had to acquit. And you know, of course, as a prosecutor, I didn't have a whole lot of time to respond to this. I had to stand up and give a response to 18 points of reasonable doubt that she had well thought out. She sat down and thought them all out and thought them all through and had her arguments. I mean, she had months to prepare for the trial. So she was able to articulate what her points of reasonable doubt was. It was incredibly effective. Because usually in that second argument, the prosecutor can do all kinds of stuff, right? They can do all kinds of stuff. But generally, if you force them to respond to points of reasonable doubt, it is an effective way of arguing reasonable doubt. And that's what I saw Steffi Jaffe Owens do, and it was very effective during our trial. Just okay is not okay. And another great illustration, right? Now, if you don't know, AT&T did a whole series of commercials where they said just okay is not okay. And there were all these little short clips. And the clips are great for illustrating. I mean, we make decisions about food all the time. People make decisions about food all the time. And there's several different analogies that you can get, several different arguments you can get. I mean, everybody's heard the argument about the rancid soup, right? Or the argument about the soup. When I first got engaged with my wife, I spent a couple of years trying to impress her. And a couple of years trying to impress her, you know. And I still spend time trying to impress her because I love her. But in any event, there was one time I took her to a French restaurant, and I thought we were doing some stuff because we were at this fancy French restaurant. The cheapest thing on the menu was like $70, and so you know I was gonna spend some money, but it was all right because I was with the lady I loved and I wanted to impress her. And so we go into the restaurant, and she orders this turtle soup. You know, and I was like, man, turtle soup, that sounds pretty good. And so they bring her this turtle soup, and they put it on the table. And this is the fancy French waiter. He's speaking in kind of like this English. English is broken with this French accent, and all it seems genuine. And then there's this nice wine list, and they bring this soup out, and they put it in front of my wife, and she looks down, and there's a fly in her soup. And she says, Eric, there's a fly in her soup. And I said, there ain't no fly in her soup. This is a fancy restaurant. This is a great restaurant. There isn't a fly in her soup. I looked at her soup, and I saw a fly. And the fly looked back at me, was doing breaststrokes and backstrokes all up and down her soup, was moving all around her soup. So I yelled out, waiter, waiter, waiter. And so the waiter came rushing and says, yes, sir, yes, sir. And I said, sir, there's a fly in her soup. And he said, there's no fly in her soup. I said, yes, there is. And so he looks at her soup and sees this fly. And then he runs off, and I said, all right, baby, they're going to get you another bowl of soup. Everything's going to be all right. Don't worry. We're at a fancy restaurant. They're going to do that. He runs back, and he has this big spoon, and he swoops in and takes the fly out with the spoon and then says, bon appetit, and then rushes off. Ladies and gentlemen, the state wants you to eat that soup. There's a fly in the soup. Snitch number one has been swimming all over in the soup in this case. He's been in the evidence. He's the one that they use to collect the evidence. It's his statements, his testimony about what our client did that they want you to use to convict our client. There's a fly in the soup. None of us would eat that soup. Throw that soup out. You know, you can go on with it. You see the argument that you can make? And so the argument with food just is endless, right? It's endless. There was a mother who used to get apples and all, and she'd pick apples off of a tree. And then one day she was out, you know, picking some apples off the tree, and she was shining them up. And if you've got an apple, it's good to use it if you're using an analogy like this. But she'd take apples and shine them up, and then, you know, she wanted to go ahead and go inside and cut them up and give to her children. So she went inside and she slit the apple up, and then there was a worm inside the apple. So she looked at the worm and said, no, and she threw the apple away because she couldn't give that apple to her children. because she couldn't trust that apple and couldn't trust whether or not there were other worms in the apple. The state wants you to eat that apple. They want you to give this apple to the children. There's a worm in this apple, and whatever issue you might have pointed out as being the worm in the apple, the worm in the apple. And then rooting for the mouse, which is another story that's not related to any video, but rooting for the mouse. If any of you have heard this story, it's one that I love. And generally the argument goes like this. We all would agree that the state can prove his case beyond a reasonable doubt using circumstantial evidence. Everybody would agree. For example, take if you had a mouse and you put him inside of a box, right? And then you took a cat and you put him inside that same box and you put a lid on top of the box and you sealed it up with some tape. And you waited 10 to 15 minutes and you went back to that box. You took the lid off. You knew the tape wasn't disturbed. You lift the lid and you look inside and all you see is a cat. And he's a happy cat. All you see is a cat inside the box. So circumstantially, we didn't see the cat eat the mouse and we didn't see what happened with the mouse, but we can assume, and pretty certain we can assume that the cat ate the mouse, right? But consider that same box and you put that mouse inside that box. And then you took a cat and you put a cat inside that box and you sealed the box up again. And then you left for another 10 minutes or so. And you came back to that box and opened up the lid and all you saw was a cat. But when you look closely at the box, over in the corner, maybe the size of a quarter, you see a small hole large enough for a mouse to fit through. Are you sure that the cat ate the mouse? Or do you have some reasonable doubt that that mouse went out of that hole? That hole, ladies and gentlemen, is a reasonable doubt. And here in the state's case, there are a lot of holes, a lot of holes. So another illustration that kind of illustrates, reasonable doubt, a way to argue and define reasonable doubt for a jury. So my uncle, James, lived to be 78 years old. And my Uncle James was a good man. He was one of the best men that we knew, one of the best men in my family. If he told you something, you could take it to the bank. His word was his bond. He cared and loved for people. He was just a great man. When he was about 74, he ended up falling and striking his head while he was working. And he went to the hospital. And while in the hospital, he fell into a coma. And the doctors came to my aunt and told us, we don't think we're going to be able to revive him. And we suggest that we take him off the ventilator and that you allow him to die peacefully. And my aunt, who loved my Uncle James, and my other relatives who loved my Uncle James, asked the doctor, says, well, did you perform any blood tests or any blood work to see if he's brain dead? Did you do any of those things? And the doctor told him, no, we didn't do those tests. We didn't do any additional blood work. And my aunt said, well, why didn't you do those tests? And he says, well, your insurance doesn't necessarily cover those tests, and we don't need to do those tests because we have some other indicators that are showing that he is not going to respond and that you need to enter, or at least allow us to not resuscitate him. She didn't agree with him. And she went out and she found a different doctor and asked him and had him move to a different hospital. And they did some tests. And when they did some tests, they realized that he wasn't brain dead and that he was actually going to survive if he had certain care and treatment, that if they had waited a little while longer, that he would have survived. Ladies and gentlemen, the state wants you to pull a plug on my client. Don't pull a plug on my client. Don't pull a plug. Because in this case, they didn't go out and have the DNA tested. If they had the DNA tested, there may be some issue, some reason why we shouldn't pull the plug on it. You see how the analogy can go? How far you can go with it, how many different things you can do with an analogy in regards to health as well. People make those kind of decisions. Those are the gravest decisions you have, even if you get a definition of reasonable doubt, right? Most of the definitions say that the care that you would take in taking care of the most important of your affairs is what a lot of the courts and a lot of the states that have a definition of reasonable doubt define it as. Those that don't, you still put people in the idea that they have to make a framework. This is just important, right? Isn't it life, liberty, and the pursuit of happiness? Without life, you can't have anything, but without liberty, you certainly can't pursue happiness. The framing founders put it in that order for a reason, right? It's life, liberty, and pursuit of happiness because it's an order of importance. So shouldn't we have the jury in the framework that they've got to make decisions with life at stake? With life at stake. Reasonable doubt is for you. He mentioned that I was at the Trial Lawyers College. I was on staff at the Trial Lawyers College. This actually comes from Jerry Spence. It's something Spence does that I think is very effective, and I've used it in trial. He starts it in voir dire. He starts off by asking jurors, what do you think reasonable doubt is? And then gets them into a discussion. And then during the course of his discussion, he says, why do you think the standard is so high? And most people will say to protect the defendant. We're trying to protect his rights. We're trying to protect him from being falsely accused or falsely imprisoned. And he says, well, all that's well and good, but the reasonable doubt standard isn't for the defendant. It's not for the defendant. It's for you. It's for you because 20 years from now, you're going to have to live whatever decisions you make. 15 years from now, 30 years from now, 40 years from now, however long you live, for the rest of your life, you're going to have to live with the decision that you made concerning the defendant. If there's a situation that you made concerning Mr. Jones, my client, you're going to have to live with that decision. So that standard isn't necessarily to protect him, it's to protect your conscience and to protect you. And so I use that all the time in closing argument in one form or another because it's true, right? Reasonable doubt isn't just there to protect defendants and our clients, it's there to protect the jury. And if you can get them thinking that way, most people will take that decision fairly gravely. Because as soon as they walk into the door, the prosecutor's attacking reasonable doubt as a standard, saying it's not that high, it's not that important, you don't have to be that sure. They're attacking it. But most people, when they're making decisions, even if they're buying a house, right? If they're buying a house, they're going to get a house inspected. They're going to be looking at it. If it's got problems in the foundation, they're not going to say it might have problems. It has problems in the foundation, and I'm not going to buy that house. They make decisions based on how serious things are. And if you can get them thinking that this is your client's life and they've got to live with the decision, this isn't some trivial matter, they got to live with the decision, then you have a greater chance of having the standards being high. Has anybody ever talked to juries after trials? Like months after trials, not right after trials. I had a case, and it was a case where my client was accused of stabbing someone 121 times. And we tried the case 3 times. The first 2 times were mistrials, hung juries, that kind of thing. But the last time we tried the case, the jury convicted our client. And it was one that I couldn't sit well with. I mean, it was a case where there was good evidence against the client. There was DNA evidence all over the crime scene. And the guy was stabbed 121 times, and my client's DNA was there. And my client admitted that he was there. But it still didn't sit well with me. So probably, it may have been 2 months later, I called one of the jurors to try to find out what went on. And then she told me this, which kind of blew my mind. She says, "Oh, Mr. Davis." I said, "You remember me?" She says, "Of course. I think about you every day. And I think about Ivan, who's my client, Ivan every day. I think about him every day. How's he doing?" She asked me. And I said, "Well, I think he's not doing well because he was convicted." And she says, "Yeah, we really wanted to find," and we started talking about the case. She remembered all of the details some months later. And I'm willing to wager if I called her 2 years from now, she still would remember it. She told me she had difficulty sleeping months after the trial. So with the jury, when the jury is dealing with our cases, if you've done a good job during the trial, if you've done a good job picking a jury, and you've done a good job advocating for your client, and most of you will, most of them will take it pretty seriously. And if you can point them to reasonable doubt being there for them, it can help you and go a long way. So we got a gift. I got a gift, at least. When Attorney Bevel was talking about this gentleman, he talked about the Honorable Eugene Pincham. And so I looked it up, and I looked up the story he used, and I thought it was a great story. He told this story in trial, and I think there's some applications that we can do now, changing the story a little bit, because nobody really is buying sugar by the barrel anymore. But the Honorable Eugene Pincham said that his mom would buy sugar, but at his time, they'd have to buy sugar by the barrel. They'd buy large amounts of sugar. And every now and then, his mom would always say, "Hey, look, y'all can get some sugar, but I need to be there and watch you doing it. I don't want anybody getting any sugar unauthorized." And every time when they would transgress against their mother's advice and get sugar, she always knew. And Pincham said he thought his mother was clairvoyant, that she could always just tell whenever they did anything wrong. But when she got older, before she passed, he went in and he asked her, says, Mom, how did you know that we were always getting sugar? And then she told him, she says, whenever I go into the kitchen, there were all these little granules left around that would tell me, because I kept a spotless kitchen. So whenever I go in, I'd see all these little sugar granules that would always tell me that you guys have been here. Those sugar granules are the inconsistencies in the state case. You see all these, and he'd make that argument that the sugar granules that are left, the different things that are left, are traces for the jury to be able to see reasonable doubt. He used that story. I think we can kind of play with it a little bit, because, I mean, nobody buys sugar barrels, but people buy cookies, right? A mom buys cookies and keeps them in a cookie jar. She keeps a meticulous kitchen, and she comes in and she always finds cookie crumbs on her shelf. So she knows somebody's been in the cookie jar, and she knows there's only 2 people who probably went in there. You follow? So we can kind of work with that and make that argument ours. Can you see it? Even from that story, can you think of something in your life, a situation, a story from your life experience that you can kind of turn into a reasonable doubt story, something that you can use to argue? I mean, I think we all can in terms of our life experiences and the things that we've experienced. So using reasonable doubt charts. Now, I've seen lawyers use reasonable doubt charts, and have any of you seen lawyers use reasonable doubt charts to argue reasonable doubt? Right? The argument usually goes something like, reasonable doubt's the highest burden. It's the highest burden you have. You got down here, but there's no evidence. If there's no evidence, you got to say not guilty. If there's a scintilla of evidence, which is just a little bit of evidence, it's still not guilty. If there's reasonable suspicion, it's what police officers use when they're stopping suspects. It's not guilty. You got probable cause, it's what a police officer used to make an arrest. That's not guilty. You've got to get past clear and convincing evidence, which is the standard we use if they're trying to take away somebody's children. It's got to be clear and convincing evidence. It's got to be more than that in this case, right? That's how the argument usually goes. Anybody see it done that way? Okay, a bunch of people. I suggest that you don't do it that way. I think it's an effective way to do it, but it's not as effective as it could be. I suggest that you use story to do it. Now, I got up here a bunch of different charts. The same arguments kind of apply to all of the different charts, but I suspect, at least, and this is in your materials, if anybody wants to use a reasonable doubt chart, I've got them all in the materials that I'm giving you. I'm giving you copies of all 4 of these different ones. This is a great one, I think, that kind of spells it all out. But my suggestion is you do something a little different, that you use story in using the reasonable doubt chart. For example, you might say, ladies and gentlemen, there's a whole bunch of standards. Reasonable doubt is the highest standard, right? The highest standard. You got probable cause was the standard that's used to arrest. Let's say you got a guy running, carrying a television set, and a police officer sees him running and hears an alarm going off. And so he sees this guy running, carrying a television set, and hears a burglar alarm going off. He's got some reason to believe that a person has committed a crime and that guy committed a crime because he's running. And so he stops and he arrests him. I mean, that's probable cause. That's what the standard of probable cause is. And no, mind you, that the guy's carrying his own television set that he bought, and he's running because he's worried about it raining on him and his television set. And that the burglar alarm going off has nothing to do with him. It's still probable cause for a police officer to make the arrest. Or let's say you got, clear and convincing evidence. The evidence has to be clear and convincing, ladies and gentlemen. It has to be clear and convincing evidence. And we tell you that that's the standard that's used to take away somebody's child, right? It's got to be clear and it's got to be convincing. Let's say you got a mother who spanks her child, disciplining her child, because she believes that she disciplines her child. And her child, who's 13, is a little upset. And he goes and he tells the teacher, my mama, she hit me with a paddle, and then she went at me with a metal rod, and it caused a little bruising on my butt, and everything like that. The bruising healed, and then they call CPS. CPS comes out, and they take the child from the mother. Oh, mind you, that the mother doesn't hit him with a bruise, with any rod. They see the injuries and they think it's clear, and they hear the testimony from the child and they think it's convincing for them. And so they go ahead and they remove the child from the mother. And then they start proceedings to try to terminate the parental rights. Mind you, that she's never hit him with any bruises or any rods, and that she'll come in and she'll say that I never hit him with a bruise and a rod, and that most of the people will tell you that child's a disciplinary issue, all those things, but there still is clear and convincing evidence. Do you see the difference in just making an argument, telling what the standard is, and using story to sort of illustrate each of the different burdens of proof? And I think that's the power of story and using story and illustrations and analogies. I think I'm just about up on time. I may have a few minutes to answer some questions. I got 10 minutes. So 10 minutes, okay. 10 minutes. I had a whole bunch of other ones that I cut thinking I wouldn't have time. But I have 10 minutes to answer any questions. Yes?
Catch it in the motion and lemony hearing. And I love the idea of scouting about it, but can you give us some examples of how to handle that? And is there any concern that if you're objecting to what the judge is doing, that it may hurt you with the jury? I mean, I know you have to preserve your record, but you're having to balance all that out.
So Robert, thank you for that question. And I'll say this. Most juries expect lawyers to object. So this idea and notion of, I don't want to object because I don't want to be an obstructionist. I don't want the jury to look at me negatively because I don't want to object. I think that's not 100% accurate because most jurors think we're going to object. You follow me? And they don't really keep score of when they're overruled and when they're sustained. Now, definitely there's a point where you're over-objecting, where you're objecting to everything, you're constantly objecting, and that may be problematic. But definitely, you still want to object. That's the first thing. Second thing is, I would suggest alerting the judge to the fact that you are going to object. In other words, you may want to talk to the judge prior to the trial and say, Judge, how do you want to handle any objections that we have to the court's statements? If during your voir dire, if we see something objectionable, how do you want to handle it? Some judges will say, just go ahead and object. Just go ahead and object when you feel it. Some judges will say, well, just ask to approach. If you're going to object to what I'm going to say, ask to approach and we can discuss it at the bench. So I would ask for permission ahead of time, figure out how I want to handle it, and then proceed. An example of something that happens that's objectionable with a judge is in voir dire, if a judge says, the law doesn't give, in Texas, we don't have a definition of reasonable doubt. Let me preface it with that. There's no definition of reasonable doubt, but judges give definitions of reasonable doubt all the time. Right? So judges will say, in Texas, the legislature's taken away the definition of reasonable doubt, and they leave it up to you. Reasonable doubt is what a jury, each juror, individual juror wants reasonable doubt to be. We don't have a definition of reasonable doubt, so you define it how you see fit. They'll say something like that. They'll say, but reasonable doubt isn't 100%. You don't have to be 100% sure. They'll say that right afterwards, which is objectionable because it is a definition of reasonable doubt by telling them they don't have to be 100% sure. Right? It's different by saying that you don't have to be 100% because for you to be 100%, you'd have to witness it yourself, as opposed to saying 100% sure. I can be 100% sure even if I haven't witnessed something myself, if I believe all of the testimony beyond a reasonable doubt. But judges define it as if you don't have to be 100%. So you'll have some jurors who may be on the fence, who may say, I have some doubts about whether or not the defendant did it, but who'll go along with guilty because they'll be told you don't have to be 100%. You don't have to be 100% sure. So yeah, you're not sure, you have some reasonable doubt. You don't have to be 100% sure. That lowers the state's burden. And it increases the burden of reasonable doubt. So an objection in that situation would be, objection, Your Honor, that violates the defendant's right to due process. Or objection, improper voir dire, that violates the defendant's right to due process. That would be how you'd object to that. Does that answer your question, Robert? Okay. So Robert just says it's difficult to make the objection when the judge is doing it. You don't have to say what he just suggested. He says it's hard to tell a judge that you're violating the law. You don't have to say that. You can just say, objection, Your Honor, that violates the defendant's right to due process. Or objection, due process, anything like that. You just need to make the objection enough to preserve the record. What happens, I did this with a judge. Anybody familiar with Judge Jan Crocker, who was in Houston? She was a very prosecution-oriented judge. Yeah, I tried a case with Judge Crocker. I stood up and objected during voir dire in Judge Crocker's court, saying that, objection, Your Honor, that violates the defendant's right to due process. And then she stopped and she said, well, how so, Mr. Davis? She asked me that in front of the jury. And I explained to her how so. And she says, ladies and gentlemen, he might be right. And so I want you to disregard what I just told you. Yes, a judge changed course during voir dire from an objection. You follow me? So there's value in objecting. And I'm sorry that was the only thing you got from my talk, Robert, but I'm glad you got something. Any other questions? Yes.
The gentleman asked you earlier that relative to the instruction. My question to you is, how do you cover yourself and ensure this is documented in the event that the court denies you ever said anything to them earlier? So should you maybe put it in a written format before you leave the chambers?
You could even put it in a motion in limine if you'd like to. That'd be a way to protect yourself. I mean, that doesn't preserve the record, putting it in a motion in limine. That doesn't preserve the record. You still have to make the objection. But if you want to alert the court to it and you don't want the court to be breathing down your back, put it in your motion in limine as well. So that any definitions of reasonable doubt by the court or the prosecutor, We'd ask for motion in limine. And when you're talking to the judge about it, say, yes, judge, we ask you not to give any definitions of reasonable doubt either, or any definitions that violate the defendant's right to due process. You could do it that way, or you can file a written objection if you'd like to. If you got some law, and there's some Supreme Court law, and in fact, there's an extensive amount of cases out of the different circuits. The Third Circuit, I think the Ninth Circuit, and the Seventh Circuit. There may be some others as well, but there are a lot of different U.S. Court of Appeals that have already weighed in on the issue. So there are tons of situations and tons of circumstances where they've overturned cases and convictions because of an improper definition of reasonable doubt. So there's a lot of law, a huge body of law. You just need to file a written objection if you so desire, if you're trying to preserve the record and cover your butt. Anyone else? Yes? The objection part or the part about arguing reasonable doubt? Oh, all of it. All of it applies. Even though you might have a definition of reasonable doubt, most of the time the definition doesn't illustrate it, right? It doesn't give a circumstance. It may be language like it is the standard that you use in making the most important decisions in the most important aspects of your life or something like that, right? Which doesn't really you can argue that, but it doesn't really give the jury like teeth. It doesn't give the jury a way to see what it is. Am I making sense to you? You follow me? It doesn't illustrate reasonable doubt. So definitions and analogies and stories that you can use to illustrate the most important aspect of your life, right? Or things that you can use to argue reasonable doubt, even if you have an instruction. I think with an instruction, it's even more helpful to have an illustration or analogy or a story to use. And I would say this too, just because people have been giving the instruction and the court's been giving the instruction doesn't mean that it isn't objectionable. So I would pull back and see. Now, if your judges are like mine, I want sometimes, not always, with some judges, I want them reading the charge on the record. In other words, I want the court reporter to transcribe them reading the charge. There's some judges that won't, the court reporters won't transcribe the judge reading the charge. And I'll tell you, judges ad lib sometimes when they're reading the charge. They'll add in stuff. Good. So if you got it on the record, there are often times where a judge, during the course of reading the charge, reading a preliminary instruction, will ad lib and go off script and explain some things. Sometimes those things are objectionable. I wouldn't just automatically just assume that, yeah, it's a preliminary instruction, it's what everybody gives in New Jersey, it's not challengeable. You still can challenge some of that, or you still should look at it to see if it can be challenged. Does that make sense for you? Okay, because like she said, we got Batson because somebody objected, right? It was what everybody did at one time, but somebody objected and it changed the law. And in your state, it could be the same situation. Okay. Any other questions? A couple of more? Yes, sir? Not always. Not always. See, where I practice and how I'm conditioned. Her question was, I'm curious as to prosecutorial misconduct if a prosecutor overstates and he argues things that are unconstitutional or that are improper. Should you object during opening statement and closing argument? And if you do object, is a curative instruction enough? The way I practice, I'm a little bit conditioned because to preserve error in our state, you've got to not only object, if the objection is sustained, you've got to keep going until you're overruled. That's the easiest way to remember it. So you got to object. And if the judge says sustain, you got to say, Judge, we ask that the jury be instructed to disregard. And if the judge gives the jury instructions, should the jury disregard that? Then you got to move for a mistrial. And the judge says denied, then you preserve the issue for error, right? So we're conditioned that we go through it all. And I would suggest to you that it's never enough, especially if you want to preserve error. Because if you don't object, and even in your state, right, if you object and the judge sustains it and you said, Your Honor, we'd ask for a curative instruction, and the judge gives a curative instruction, what if the curative instruction isn't enough? What if the curative instruction isn't enough? What if some people hear that and they're still thinking, I heard it now. I know that he'd been convicted of some other stuff before, so I know that now. I'm not going to really be able to unring that bell. What do you do then? Do you stay satisfied? No, you move for a mistrial. On that issue, you move for a mistrial. And there's no harm. The rule that we learned in law school about not objecting during opening statement and objecting during closing argument as being rude is ridiculous. Now, you don't want to object like 50 times. Now, you don't want to object to a point where you're obstructing things and constantly being overruled, but definitely you want to strategically object if somebody's arguing something improper. You want to preserve the record because you might not win. You want to win, but you might not, and you've got to preserve the record by objecting. Does that help you, ma'am? Okay. There was a couple other questions.